Yeah.
Hello.
Hi, can you hear me?
Yes. How are you?
Oh, good.
I'm going to get
Something
my
about the
headphones.
second time. Great.
All right.
And so this will transmit.
The sound as well, correct? Yeah. I can hear someone else in the background, but it's really muffled. That's because I just... Oh, no, I can't hear anything. Sorry, I'm untangling. These things get so tangled up. Almost there. Ooh, it's going through that. But could we switch it to that?
Yeah.
But she needs to be able to hear. Kristine, can you hear us?
Yes, I am good.
So
I can hear. How's it going?
Really good. Oh, this is great. We're just gonna get the PowerPoint set up, but everything looks good on your end.
Okay.
Okay.
And we have a half hour until the program starts, correct?
Yes, that's right.
Okay, perfect. How's my sound in the room?
It's really good.
Anything else you guys need me to test out?
No, you don't have. You have PowerPoints?
No.
Good. Okay. I like that answer.
Does make things easier.
Yes, definitely. Okay.
So I can hear you clearly. Hopefully I'll be able to hear everyone else, all the other speakers, and the moderator.
Yes, I think
through whatever the same sound system is.
So, if anything, we just might need to turn this volume up a bit. Okay. No, this is a lot easier than I thought. I'm thrilled. And I think you should hear the panelists just fine, because if you can hear me fine, you're going to hear them from the speakers fine.
Great. Will I be able to see any video? If not, that's the way it is, and it's okay.
No, you will be able to see the PowerPoints.
Oh, good. Okay.
Great. So let me try and pull that up very quick.
And then when will so I'm assuming based on previous times when I've had someone join by video conference that my face will be like 6 feet tall on the screen behind Rachel and Preston.
Yeah.
Okay. So I will be sure. Yeah.
You are currently on the screen, but you're not full screen.
Okay.
So you are about the size of a normal face, comparably.
Ooh. Okay. So, good.
And then we have my dog in the background, because she's my screensaver. I really quickly am just going to set up the PowerPoint. So if I don't talk, that's why.
Okay. Do you mind if I put myself on mute and wander around the house
Yeah,
for
totally.
about 20, 25 minutes?
That's perfect.
Okay, great.
Great. You don't have a USB drive that I can use. Thank you. No. Oh. Are you seeking feeling? No. Okay. Wonderful. Oh my gosh. Hi. Well, that makes me feel a lot better. And so we've got Kristine Bowman. Yeah, so she is up here on the screen. She's in another room now, but okay. And wonderful. Is it on there? Okay.
And I can show you where it needs to be corrected. I caught it, but I didn't bring my laptop with me because it just felt like so much heavy weight.
Hi, how are you? Nice to meet you, Matthew. I'm Allie. Pleasure to meet you. I love that. Keep talking. No, that is not true. You all are the subject matter experts, so that this is about you. Sure.
Okay.
Great.
Yeah, I think we can do them still, but it's more complicated. It's the Latinx and the future of schooling. The other ones are from class. And another document. So I can give you this the slide where I wanted to make a change.
Great.
Oh, so Kristine's she's on.
She is. Yes, okay. She's on. Yeah, we just wanted to make sure that right? Running smooth. Running. I love you. Oh my goodness. Yeah, I don't like waiting. Yeah, it's such a great time.
Actually, I was really concerned. So I read it. I love it. Pretty much things like they're on par right now.
Yeah.
I'm wondering.
You can save it to my flash.
Yeah.
That they're
I'm wondering, can we use? Okay, so could you email me? Yeah, just because for some reason his emails aren't going through to my phone.
if you want to save it,
That's a good idea.
and then I can take it back to that. So wait, there's a tendency to forget the drive.
Yeah, we don't want to do that.
Because you're running out the door, you go back to the airport or whatever.
You're right. I'm leaving after this.
Yeah, exactly. So
Did you see my
when
suitcase?
you're getting on, it's like, oops, I left.
Thank you so much. How you feeling? Can I get you on anything?
I'm just happy to be here. Happy to see you.
Yeah.
Some of our
If you could just walk around to everyone who's here and just ask them, make sure they're fine and everything. There's only 3 folks. So I'm thinking that I can and like ask one or something. I really Yeah. Yeah. I was just surprised that
Did you get my email?
we got it.
Okay, well, it's still good.
I didn't understand.
Okay, I don't know what's going on with this.
Everyone, I just checked them wherever.
I guess I should.
Yeah. Okay.
Oh, yeah, make sure you get the right shot.
Oh, yeah. And are you going to say that this is, I'm not speaking on behalf of Vanderbilt law? Is that what they? Oh, okay.
Turf issues.
Okay, so one question. So I can do this with her. Do we want her face up even during the other PowerPoints. Okay. So I will do my. Yes. 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 Yeah. Okay. Yes.
The way that I am structured, give a general broad overview and have relationship of general and that's where most people learn to
Yeah.
say, well, here's what has happened around all the conversations about how the location and what that actually is.
Yeah.
Some of the legal questions, creating the social science, which is used especially for practitioners. There's not as many connections between social science and practice as there ought to be, particularly in education.
Yeah.
Finally, Kristine, I'll have her talk about guarantee litigation, under litigation, and other litigation related. And then I have some questions to the panel, and then I'll open it up.
Okay. So I just want to go through the slides with her face in a corner, and then wonderful. Okay.
Just one of the questions very quickly. There were, when I was trying to, I said to her, candidate feedback. Well, I was concerned because, like, I was going to start talking. I stayed focused on segregation, right? Making sure not to talk about some of the other stuff that I write about in case that's going to come up.
It was definitely, there's no way.
All right, so.
And I think a lot of people here are going to know how to ensure to a
Okay.
So you have an interesting thing. I mean, again,
any of us can do it by yourself. Okay, but I just wanted to be sure that was okay because I was going like, I'm getting covered. Because I was going to start trying to do that, and I thought, well, I can't get so that's a whole other not go down. So I just stopped. So I just wanted to touch.
And then because I was trying to look at the like from Brown to now, you don't want to do that. That's so much. Like that's a course. And even then you couldn't cover it. But I think it's a good way.
Okay. So that's good then. What I'll do as far as the social science data goes, is like I just sort of left it like saying here's a clear people to read, because there are two ways of doing this. It's like, well, there's validity, there's this, there's that, and there's all these other things. Like, these people do this to people. Exactly. Okay. All right. Okay. That's good.
It moves it to the back. Oh yeah. For her date on that. Okay. But then you won't be able to what about if we, is that right? You know, because it's just but anyway, no. What if we have somebody viewing it? Who's PowerPoint? There's two. So what if I have this and the one that's presenting is an intern who's watching it? You know, what if we have it go live so that they see both, correct? So I'll share my screen. You know what I mean? No, one up to that. I know. So one up would be the intern watching the full thing. When you present it, so if they register for the program and we're going live, you'll see both my computer, which is having PowerPoint go through. Yeah, right. We'll do that. So I need you to register for this program I'm about to send you. All right, can you about my computer? You want me to bring my computer? Yeah.
Have the trigger here.
Wonderful. Oh, I want to make sure it'll work. It's not. You'll just.
So this doesn't work? I have one that does.
Well, yes.
How is it not? Is it?
So do you have one that will?
Yeah, I mean, this one.
Oh, okay. Okay. Yeah, let's try it.
Yeah.
Right. Okay, so we're just figuring out something. So real quick. Oh, I don't need it. I'm so sorry. I'm sorry. She's going to grab it. Okay. Oh, it's not. It's he scans it. Okay. Just whatever you need. Can you get that? Yeah, great. Okay. Can you? It sounds no.
What do you mean? You know, when it's going to be recording?
Yeah.
Is that an issue?
I have. It's not very long though. Time is it? You okay? Great thing is we're recording it, so we'll have it available for replay on our website, and we can advertise it widely.
Okay.
No, that's fine. Okay. Moving on here. Personal email, or are you logging in? Yeah. Can you log into yours? What's your email? Or can when you're ready. So how do we start the webinar? Oh. Oh no, you're totally fine.
Can she see me?
Can you hear us, Kristine? Yeah. You're still on mute. No, she can't see you.
I can hear you, but I cannot see you. I can see Rachel's first slide.
So
Oh,
we can share our webinars.
Okay, so I see.
We can share our webcam, and then, but we don't want to see that up there.
Got it. So whatever is on the screen, that's screen goes to work.
She'll see.
Okay. Sorry, I can't see you, Kristine, but I'm waving at you anyway. Hello.
Oh, thanks. Good morning. How are you?
I'm well, very well.
Did you get it?
Thank you for joining us. We really appreciate it.
Can you see? Is it started?
Yes. Thanks for figuring out the logistics and making it possible.
We should be going in around 5 minutes. We're just waiting for Rachel and Kristine to get to the stage.
Sounds good. So remind me, this is about the middle of the conference? Ooh, I see Matthew's email. Or an email from Matthew or something? Ellie, am I looking at your... Just so you know, I'm seeing somebody's
Oh, this is me. Sorry.
Outlook. Yeah, okay.
Because I just
Which is,
took the
I mean,
other.
I can avoid looking at it, but you probably don't want it on the screen or in the webinar recording.
I don't. Yeah, that's true. Okay. So what you want to do is extend screen. So right click the background.
So Christy's on the screen. We have to click like her work. So when you switch from Rachel's presentation to yours, you hand off the clicker. Okay.
Yeah.
I have to do that around 10 for the airport.
Great.
Excellent.
Great. Okay. Wonderful. So remind me, we're going, well, obviously Matthew, and then I guess.
Nah, I don't know, but I can call it. Okay. Can you exit out real quick?
So do you need to?
Did you play a sound or something? Yeah, something to play.
Sound?
Yeah.
Oh, is that Kristine? Can you speak?
All right. How's my volume?
Can we turn that up?
Yeah.
Can you hear me?
Can you hear us?
Do you need me to keep testing?
Great. Perfect. Can you test one more time? Kristine, can you test one more time?
Okay.
Great.
Good morning. It looks like we're about ready to get going. And I appreciate everyone making the logistics possible for me to join and figuring out all the AV details and making it so that I can be heard and yet I'm not shouting at everyone in the room and fine-tuning all of those things. How's my sound now?
Perfect.
Great. Thank you very much.
You should be able to put this.
Good morning, everyone. My name is Matthew Shaw. I'm an assistant professor of public policy and education at Peabody College and assistant professor of law school. And I would like to welcome you to this morning's CLE, From Brown to Now, Legal Responses to Resegregation in Schools. So we are very, very fortunate to have with us three distinguished professors who study education law, education policy, the intersection among those, and most importantly, for purposes of this CLE, how we can respond to in desegregation in ways that are going to benefit education for all children. So I would like to introduce our panelists in the order in which they will present. And after their presentations, I will moderate questions. I'll ask a few that I prepared based on what they had intended to present, and then I'll open it up to the audience if you all are fine with it. So first, I'd like to introduce to my far right, Dean Emerita Rachel Moran, who is also the Michael J. Powell Distinguished Professor of Law at the University of California. And seated next to her is Professor of Preston Grooves, Professor of Education and Law at the Dean School of Education at the University of Connecticut. And joining us remotely, thankfully, is Professor Kristine Bowman, Professor of Law at Michigan State University. So please give our panelists a round of applause.
Well, first of all, I wanted to thank Matthew for inviting me to speak. All of you for attending the panel. I want to talk a little bit about issues of segregation in the Latinx. Now, we're going to have to hear you. So, issue of segregation was born. My problem is on voluntary integration plan during the 1970s. And she said, I was a little girl in Berkeley who was part of one of those voluntary plans. Now, that brought segregation back to public attention. One time it hasn't really been very prominent in the news. And the next day, the newspaper found that America's students were segregated in 1970 in this moment. And what they really talked about was the situation of Latinx students and the changed civil rights landscape, the very altered toolkit we have to deal with questions of segregation. So that's what I started about with you today, beginning with the demographic transformation of our population. So in years, the Latinx population has actually been a key driver of our demographic growth, and it's really transformed the nation's racial and ethnic makeup. So if I wanted you to just guess what the current Latinx population is, throw it out there for more than 20. Okay. Right now, what do we think it is?
Oh.
But in any event, it's 17% now. It's actually up to 18 just recently, the new statistics. It was I'm sorry. But in 2060, that population number is going to be 31%. So basically, what we have level of representation of Latinx is larger than racial or ethnic history. So if you think about the peak of the civil rights movement around the 60s and 70s, when Kamala Harris was doing a voluntary integration in Berkeley, the total population of people who identified as non-white is 10%, and 9 out of 10 of them. So just to dig a little bit deeper into that demographic picture, what you can see here is, this was done by Jennifer Ortman, census, that in 2012, people who identify as white alone racially constituted 78%. But out of the top part that are non-Hispanic white is 63. But what you see by 2060 is that non-Hispanic whites are going to constitute only 43% of the population. That will be the first time that whites are a minority, non-Hispanic whites are a minority. But the other thing to bear in mind here is that the Latino population, the Latinx population, account for over 30%. And so taken together, right, these mean that the gap is only 12% between the Latinx population population. There has never been such a small gap. And there's been an assumption that the Latinx population is a regional population concentrated up here, for example. That's no longer true. So, it's all right. Let's go back. So this impact is going to have an impact on American elementary and secondary schools. The Latinx population is actually youthful. The average age is much lower than for the non-Hispanic white population. And this has actually been part of the driver behind the intense resegregation of America. And so there has been both regional and national growth in the Latinx population. It is not just a regional phenomenon. And what is the so, okay, great. So the Latinx population grew from 26.4 to 26.3% between 2006 and so that means that already the Latinx population has a bigger share of the school population. Really about 1 out of 4 kids in America's schools are Latinx. But it's also grown in every region of the country. So let me just ask you to guess what you think the lowest percentage of Latinx students is in American schools. The lowest percentage in a region. So what?
One in Vermont.
Well, let's go by region. Midwest, upper south, northeast, south, and west. Okay, so that's pretty close. The upper south, which are the border states of Delaware, in that area, are about 11%. And what do you think the largest percentage share is in one of those regions? 40 is pretty close. So what you see here is that the percentage range from 11 to 13% for the upper south is about 11, the Midwest is 13. And the Northeast had about 21%, the South 28%, which is a dramatic transformation, and the West 42% of all the school children in the West are Latinx. So this is no longer a regional population. And if you look, Latinx students outnumber Asian American students substantially in every region. They outnumber African American students all but the upper South and the Midwest, and that is just about parity. And they actually outnumber white students. So this is a very substantial population. So one of the consequences of the rapid growth of the Latinx population and its transformation into a national population is that Latinx students appear to be more intensely segregated than anyone. And that includes African Americans. And so the levels of segregation have actually increased nationally for both Black and Latinx students. But the levels of segregation in the Latinx student population is rising. But it's greatest here in the West, where the numbers are the largest, whereas, for example, the African American levels of segregation are Northeast. Now, among the states, right here in California, we have the highest level of segregated schooling for Latinx students. By contrast, for Black students. So we are right now at this APA meeting, 60th state with the most intensely segregated Latinx population. So now I want to talk a little bit about, because this is about segregation and the opportunity gap, the evidence on educational achievement. So for Latinx students have actually been rising, but it's because other group scores are rising, the achievement gap has persisted. And another problem has been the excellence gap, which some argue is even bigger, which is the gap for students at the very high end of the spectrum of achievement. According to a 2017 National Center for Education and Statistics study, we continue to see white and Asian American students outperforming Black and Latinx students in reading and math. But there is some good news. So I wanted you to guess what you think the completion rate for high school now is for the Latinx population. So it's actually, that's a tremendous number. That is the bright spot in a lot of this educational data. And if you compare the first 7% for Asian American students, 95% white, 92% black students, so there's a gap. The Latinx students have been rapidly closing a high school. Now, there's some more good news, and that is that Latinx students are now actually going to college in higher numbers, which makes sense given that their high school completion rate went up so much. And so that 35% of Latinx students now enrolled. That compares to 33% of Black students, 64% of Asian Americans. So there's still a gap, but Latinx have really seen growth. So that's another bright spot in the picture. But basic college are not the most. And what you see is that 15 Latinx college compared to just Black Asian Americans, and one question is why? Why is there a higher rate of college going and still this dramatic gap in graduation rates? I think because that makes disproportionately going to community colleges, two-year colleges, partly for research, and those colleges are not always very good ways to get your degree. You get started there, but many people get lost. A lot of dropping out to work and not coming back, or working while they're going to college and not being able to work. And there's also dramatically different transfer rates out of colleges, four-year colleges, and those disparities tend to the racial and ethnic composition of those colleges. So if you go to Santa Monica College, we got great transfer. College like Latinx. So what I'm giving you is a mixed picture of the state of Latinx education, segregation, but also increasing high school graduation rates, of an ongoing gap, college enrollment, a college graduation gap. And so one question is, if you think we want to redress these ongoing issues, what can we do? And the Civil Rights Toolkit has been one thing that's so interesting about the presidential debate was that there was virtually no discussion about the end of court-ordered busing, the resegregation district, and the effort by districts to actually do something about that resegregation through voluntary integration plans or struck down in parents involved in community schools versus Seattle School District in 2007. So the very plan that Berkeley was using when Kamala Harris will have to go to a different school, but in her neighborhood is likely impermissible today under the court's decision and parents involved, because the court's race or ethnicity is a plus factor when we're doing the student assignments. So we can't give you a different school assignment based on your race or ethnicity. The situation. So that's basically what I said. No consideration for race. Then the question is, what's left? And here I want to talk a little bit about the integration-based solutions, the comprehensive school reform-based solutions, and the funding and accountability-based solutions, all with examples here in California. So if you go back to Berkeley Unified School District today, they are not able to do racial integration in this case. So they've been trying to use economic integration as the way to do voluntary integration. And they actually have about 30% of their students who are limited English proficient, 10% are limited English proficient, and 30% who are free and so they do have some diversity there. 40% of the Berkeley School District is now white, 14% African American, 7% Asian, and 24% Latin. So they have racial diversity. They can use the socioeconomic situation of free and reduced lunch to try to diversify the school. But most schools that are experimenting with socioeconomic integration are not doing assignments based on your socioeconomic status. Foundation, which is pioneering these efforts, they try to use other mechanisms like attendance boundaries, redrawing the attendance boundaries, or creating magnet schools, or having controlled choice plans without any certain restrictions. It doesn't lead to diversity. It's parameters. It can. And so what they're really trying to do is structurally based change rather than rely on individual assignment plans. That is somewhat ironic because Justice Kennedy said you could use race for those kinds of structures. With parents and parents involved, he said draw attendance lines and consciousness of the effect on racial diversity. You could use magnets and school choice, but instead, even when making those kinds of structures. So as I mentioned, diversity actually has some racial and ethnic diversity, and a little bit of socioeconomic diversity. But the use of socioeconomic integration really gives an option for California, as the population serves a tiny, it's a separately incorporated city with Los Angeles. That population is 97. And if you look at that population, 3.6% have a bachelor's. So it's a poor community, almost entirely Latinx, and also has a high economy. And so thinking about socioeconomic diversity doesn't make sense. It's frankly more ethnic diversity or racial diversity isn't any. So what they have done is to do comprehensive reform-based, and they've looked at universal pre-K. So all the kids in Korea get to go to preschool. And so they've altered the notion of what the pipeline is in elementary education. And we have data showing that there is no other group that benefits more from preschool than Latinx. So that's one of the things that they've done. And the other thing that they've done is to adopt, interestingly, a school model, akin to what was done at the turn of the century with our high levels of integration. So we identified medical care, nutrition, all of these services at the school for these students who might otherwise not have access. As well as say, a hungry child isn't going to be able to learn. Without glasses isn't going to be able to learn. And so the Elizabeth Learning Center adopted these reforms, and there's still very substantial achievement gaps. So we're down on this actually a session that some schools remain identifiable because of their constituted ethnic and nature. So then what? The final one is adopted in 2020. And it's a global control and accountability. I think this plan also recognizes pluralistic quality of the school with respect to racial and ethnic makeup and socioeconomic makeup. And so what it has done is change the funding formula, first of all. And so when you go to figure out what a school gets, they get a baseline level. But on top of that, they get grants for every set of students who have certain identifiable barriers to learning, whether that be disability, perhaps it's ELL, perhaps it's frequently used lunch. But they try then to almost like a backpack. Like we've got kids who have a heavier parent area. How do we acknowledge them and give more money to address their learning needs? The other thing that they did was to revise the way that accountability is done. And so in California, we don't use paper tests. We have computerized tests, and they're actually respond to where the student is. So it keeps track of your answers. So if your answer is wrong, your answer is right, it gives you a harder question. And that way you begin to customize the testing so that you actually understand why the student is challenged or where they're excelling. And so it has really changed the way that accountability is done in the state to try to make it more bespoke. And then with the funding and that bespoke kind of data, have to put together plans to address the issues their students are facing. Some schools are still exempted from accountability because of the population curve. But overall, I think that the idea was we can't have a one-size-fits-all for accountability and for funding because our schools are not one-size-fits-all. Our schools have very very different challenges. Someone has described it as a government around land market, actually school reform. It's still being implemented. It will be implemented, and there's still obviously monitoring the results, but I think it's very important. So, as we think about what's come to come, I wanted to say I'm going to college in 2025. How do we get our students not only to excel in school where they may be segregated, but also to have aspirations? And so I thought this is a lovely way to end at a time when I know many people feel encouraged by the situation. But there is still a lot of optimism. It's a young population, and I think that we're going to see some in this contribution. I hope all of you will think about how to help with that. Thank you.
How's everybody doing? But what's really interesting is that choice models such as charter school and private school in the educational group. And what we find is that African American parents are much more supportive of school choice models than the Democratic Party too. And so we're really in this strange position where we have these models that may possibly create education, but it's not clear where we stand right now. And also, in my research, I've discussed a lot of sort of unintended consequences for communities of color that they should be aware of if they go forward for the school choice model. If they go forward. So what I want to do is talk about three issues I got offered. And the first is with respect to charter schools and private schools. Like, they really kind of change how we approach the question, especially with respect to teacher rights and teacher rights. So I want to talk about kind of like looking at there's how does that impact how the law treats, especially, and then what's going to be done to address some of the problems. Secondly, I'm going to provide some data to charter schools and private schools. What is the actual impact on segregation nationally? I'll talk a little bit about data that actually do show. And then finally, as you all have most of you having to really navigate all of the data out there, it's important to know what's good. So instead of kind of getting a primer on how to analyze identify, look at how to access that data very quickly, get an idea of how to read it. Those are the big things. The first question is like, how has the emergence of comparison of public education defined language? So we go to the next slide. This is a charter school. And the real question here is kind of like, are these schools public or private? And what is the importance of that for students of color? So just a quick sort of overview of charter schools. They are particularly the public schools that have a charter between operator and a charter school. An authorizer is the entity that has the power to grant the charter to traditional public schools. Now, these charters last for about 3 to 5 years, and if that charter fails to meet the standards set within that charter, then the charter can be revoked after the end of that. Now, there are 7,000 charter schools throughout the United States, and charter schools serve 3 million students, and they represent about 6% of the public school population. Important to understand that while it's 6% nationally, urban areas receive more saturation in charter schools, especially in Detroit. And in fact, in the 10 areas with the charter schools, 86% of them are actually minority students. So, going to the next slide here, understand that there are new players in the charter school system that don't currently exist in public school systems. So in the public school system, but in charter schools, I mean, school districts are publicly elected, and so charter schools, by contrast, have a different approach. First of all, the charter school boards. These persons are not elected, they are appointed. And it's they actually contract with education. These are nonprofit, for-profit entities provide services to charter schools. About 35% of charter schools are now operated by education management organizations. And these organizations serve about 40%. Now, next slide. This is important because these private entities have asserted that public school laws don't apply to that people are finding some surprising. And in fact, I co-authored an article that a few years ago entitled Having It Both Ways. Charter schools benefits the public funding and the private schools. That is, they receive the funding from the public, but at the same time, argue that they're private for issues that they don't particularly like, instead of speaking rights and teaching. Now, I'm going to talk about the next. So there is a case in California started in 2000 called Scott v. Orange High School. Here are the facts that a student charter school is. So that school is finally just that student, you can't, you just bar that student for several weeks. Now, in a traditional public school, that student would receive due process. For a certain amount of time, the candidate was supposed to get due process. Have a chance to serve, have a chance to challenge surgeons. But this did not happen in the States. So the student stayed as a public school process. Charter schools said not so fast. We are not a public school. The Court of Appeals found in favor, and its argument and its conclusion was that in the context of student rights, it was not a public school, rather it was a school of choice. And the state statute, the court looked at the state statute and said, look, where you only have the same rights as private public school rights, so long as it's sensitive, where it does not, rights do not. The court also went on to say that this is not completely a private in education, that students should go to public school. Now, it just so happens that public schools are not being if we are moved from charter school. It actually, Rosa Hirji of the American Bar Association years ago pointed out that this is not the case. They're not necessarily guaranteed admission in that case. So why is this important? It's important because I think a lot of kids don't, and parents don't understand maybe these scientific their life. And this is especially important for in addition to the process. You have each First Amendment, you have urgent seizure, you have a number of rights that constitutional rights, and statutory rights that I think we should make sure that students have. And so what I have suggested in my research is that we stipulate in statute that the students have the same statutory as they would. Next slide, please. So another question that I think that I was coming to address is how is private schools and charter schools education? Now, before I start talking about the data on private schools and about private schools, you all know the private schools and segregation academies were designed as a south for white parents. I am from so I certainly learned that where the town closed down all of the academies. It's also the where, and then the Supreme Court addressed the Supreme Court to actually. So that's sort of like the history now. But during Orfield colleagues, the Rice Project, provided data looking at the 2015 attendance. What we find is it's sort of a different situation. Nationwide, enrollment for private schools by 9%, 20%. Now, white students, attendance has improved. Not only white students attend private schools. Attendance for non-whites is not that high, and it's gone down to 5%. Americans, and that's now it's important to understand as well that Black and Latinx students actually experience relatively little have contact with white students, because the gut part of everything is so small. But there's one thing while studying question like how where there's bigger, more intense voucher programs, we also have in the 5 states savings accounts. For people allotment, they can use. So as we start seeing enrollment also, we may see white students. This is something that we do. And legislators. Next slide, please. Step 2, data are a little different. Julian Matthew Kylie and colleagues published an article in School of Education Sciences that looks at the percentage of students attending in charter schools with 90 to 100% non-white population. These are schools that are studied. And what you see for Black, especially Black and Latinx students, is that charter schools are more segregated, not just in Black students, 30, contrast to the 30% charge for Black access. So there's been a great deal of data that and answer. But for those who are concerned about what like the possible effect segregation exercise, so I worked with the Central Foundation which is Central State last year, developed actually charter schools have a more diverse population. And some of the possible he suggestions have with parents involved in talks about coaches, economic status, encouraging charter schools. It also talking about local areas where you could actually achieve diverse populations. So these are sort of things that I talked about. Finally, as you all these tools that are out there to help you navigate, I want to give you some folks who are helpful actually. They come to work for legal counsel. So there are a couple of reporters who I think are really like Matthew Barney, talking is that focuses online history that focuses on education issues. Matthew Barney does a wonderful job of going through the social science research and summing up. He's very good. There are other great reporters who talk to him, but he's certainly one that I would star. Similarly, Rachel Cohen, now interested, also going to other education issues. And again, she also does a great job of as to academics, I mentioned Bruce Baker, Rutgers University. He is a school finance scholar from the finance law covers broadly. He does a really good job of talking about not just school finance, but social finance. Stephanie Kevin Bowman, professor at the University of Colorado, who also is in charge of that policy center. Member of look at issues of education. Other things actually looks at college and get the findings. I would recommend following that policy center. And finally, two persons, therefore, thank you for sure very difficult. Both provide nice project. Things are good about realizing segregation trends. Also be so guys, thank you.
Good morning. Do I assume correctly that it's my turn?
Your turn.
All right, fantastic. Well, I am so grateful to the ABA Section for Civil Rights and Social Justice, and in particular Matthew Shaw, for the invitation to join you all today and for convening a conversation about these incredibly important issues. It's also a treat to join Dean Moran and Professor Green on this panel. I always learn so much from their scholarship and hearing them speak about these issues, and so I really enjoy that. And also, before I forget, I wanted to say a special thank you to Allie at the ABA for helping me with all of the tech issues and making sure that it all is going hopefully flawlessly from your end. It's certainly flawless from mine. So what I'll be talking about today is a cutting-edge litigation strategy, and in particular, a strategy that's being implemented in a case that is coming out of Michigan right now. So to give you a quick overview of my talk, first, I'll cover the very big picture of federal law here. Second, I'll turn to Michigan, and again, a really big picture, 10,000 feet up sort of view of some of these issues. And that will lay a good foundation for talking more about what exactly is going on in this really interesting, innovative case that a lot of folks are watching. So as I think about school desegregation and school finance litigation, again, at the most big picture 10 or maybe 20,000 feet up sort of view, to me, they look something like a double helix, right? So they're always ongoing. They're always keeping an eye on what's going on with the other one. They connect a little bit, but they don't really ever intersect. And so I think that has been really interesting to think about, particularly because something I wonder about with some of this new litigation is whether that relationship might finally be changing. Now, in school finance litigation, this is where most of the right to education litigation has happened, the positive right, as opposed to the negative anti-discrimination right. So in 1973, the Supreme Court decided Rodriguez, which said, you know, there's no fundamental federal right to education, and so the right to education cases shifted to the state courts. And they all begin by looking at the state constitutional language regarding education rights. And of course, state rights to things like education are generally positive rights, whereas at the federal level, things like rights to and in education are negative rights. But since the 1970s, this litigation, the right to education litigation, has really been in the state courts. And at the time Rodriguez was decided, there was ongoing litigation coming out of about a half dozen different states. And Michigan was one of those states. Now, as we have seen with a lot of this school finance litigation, oftentimes the state judiciary's interpretation is more powerful than the language of the state constitution alone. And what I mean by that is we can take the same state constitutional language, see it adopted in two different states, and two state Supreme Courts to say that that language means relatively different things. And this is just part of how it works if we have states and state Supreme Courts deciding what these rights mean in their own state constitutions, in their own context. Now, it's interesting, though, because in Michigan, we have relatively strong language in our state constitution about the right to education. And it's pretty similar to language in about a half dozen other states. And Kentucky is one of those states. So folks who have followed school finance litigation are probably familiar with the Rose litigation coming out of Kentucky. That happened a while ago, but it is one of the school finance cases, one of the right to education cases that really got a reputation for thinking about the right to education in an incredibly robust manner. So that's what has happened in Kentucky when Kentucky has and its courts have grappled with this language. In Michigan, on the other hand, our courts have essentially said, you know, we think that this language means essentially there's an access right to education. The state needs to establish a system of public schools, so that means kids in Michigan have a right to go to some public school somewhere. not too far away, but relatively close. And the reason I phrase it that way is because in Kentucky, the right has all of these substantive elements. In Michigan, we're not talking about substantive elements in terms of quality, in terms of experiences, in terms of things that students can know and do and learn and achieve in education. So over time in Michigan, we've developed this consensus, conventional wisdom in many ways, because it's a complicated history, but the state Supreme Court has not clearly engaged with the issue, but through a number of different cases at the state Supreme Court, some appellate cases, and state attorney general opinions, again, there's this conventional wisdom that the right to education in Michigan is this sort of access right. Okay, so not surprisingly, advocates have been trying to challenge this for years and years. And most recently, they brought a case in state court that was linked to a federal statute regarding reading proficiency. And they linked did I say federal? I mean state. That's very important. I hope I did not misspeak. But if I do, I want to clarify. So they were talking about a state statute that is linked to reading proficiency and kids meeting certain benchmarks at certain ages. And so the advocates talked about that statute as enacting the state constitutional right to education. So they brought some litigation in that area, which it's interesting because the public framing of the litigation and the public aspect, the public engagement aspect of the litigation was done incredibly well, right? So the PR part of this litigation was really impressive because they called it a right to read. And what seems more straightforward, more accessible, more important than a right to read? And how could our state constitution not guarantee a right to read? Now, for various reasons, they lost in state court. And again, this was the latest in a long chain of Michigan state court decisions that were really resistant to education reform. And so these advocates then pivoted and filed suit in federal court in 2016. And in this case, it's similar in many ways, but it also it has important differences compared to the state case. And the big difference here is that this is not talking about state constitutional law anymore. This one is grounded in federal law. And so they talk about the case in the same way. They talk about it as a right to literacy case. They talk about the conditions, the physical conditions of the schools that, honestly, I don't know how anyone would be expected to learn in those physical conditions. And they also present really heartbreaking data about students in various schools across the city of Detroit, both traditional publics and charters, that are reading at single digit levels, right? So their reading proficiency is in single digits. It's absolutely shocking. Now, early on, of course, as happens in litigation, the state moved to dismiss this case. And the plaintiffs then sought to have a lot of folks involved as amicus briefing this motion to dismiss. It was pretty unusual at a procedural level. And so I was one of the folks that the plaintiffs reached out to and said, okay, can you help us add some context, add some additional information to this litigation? And so, it was so unprecedented that we were all just trying to figure out, okay, what's the form? Whose permission do we need? And we all just decided to make a good faith effort, and it all ended up working out all right. So what I was involved in briefing is the idea that the state can be responsible for something like this. In fact, essentially, it's the idea that the state exercised so much control over the Detroit district in particular for a number of years that The state cannot have that much control and also abdicate responsibility for what happens on its watch. So there was that aspect of the claim, because first, the plaintiffs needed to establish that it was appropriate to sue the state and that the state could be held liable for this. And then second, of course, is the substantive claim that there is a federal right to literacy. I'll talk about that a bit more later on. But just to stay with the chronology here, what happened is that the plaintiffs won on the state liability claim. So they won on the idea that the state could be held liable here, that it was appropriate to sue the state, and that was really unusual. But they lost on the right to education claim, because the district court said, essentially, not obviously quite in these words, but come on, folks, we all know that federal rights are negative rights. You say you're looking for a negative right, but when I think about what you're really arguing here, it's a positive right, and that's just a non-starter. So that case, of course, was appealed very quickly to the Sixth Circuit, and things continue to change as they always do. We have a new governor in Michigan since the time that the case was filed, and part of her campaign was to say, listen, the state is in the wrong here. And so it's very interesting that one of the things that has happened is that the governor, on behalf of the state, has continued to defend the lawsuit. So it's still a live lawsuit with a live question, but she's defending it more on sort of a formal procedural grounds. She's not defending it on the merits. And the Attorney General, also new since the time the lawsuit was filed, the Attorney General has stepped in as amicus and aligned with plaintiffs. So we have the Attorney General and the governor on different sides of this suit. So that is certainly very interesting. I filed as amicus, just to fully disclose my involvement with this case, I filed as amicus again on appeal. The case was in mediation for a while, but that failed. I'm not sure why. And argument has not been scheduled yet. I'm thinking it would have to be this fall, right? Because it was appealed nearly a year ago. Well, about 9 or 10 months ago at this point. So briefing has been complete for a while. So this is definitely a case to watch. It raises a lot of very important and legally unique issues, in my view. So again, one aspect is this question of positive rights or negative rights. How is this framed? Is there a way for plaintiffs to convince enough judges that they're framing this as a negative right, that they'll be able to really hold on to that? Second, again, is thinking about the state connection, because I think even if plaintiffs do win ultimately in this case, the state of Michigan has such an unusual combination of laws related to centralization of finance, school pensions, charter schools, just a whole variety of things that make it pretty unique. And of course, the state also has used emergency managers to take over school districts. And that is an important aspect of state liability in this case, in my view, is that the state has been formally responsible for the education provided in the state, and the state has appointed the person who has responsibilities for making decisions in school districts. So the reason I mention all of that is that even if plaintiffs are successful, it's easy to see how this case would be labeled as an outlier and really limited on its facts. Now, thinking about it as part of DSEG versus part of school finance litigation, it doesn't really fit in either. It's not explicitly a case about race, though of course the Detroit districts and Detroit charters, the Detroit traditional publics and the Detroit charters are overwhelmingly African American. But it's also not focused on intent in the way that school DSEG law focuses on intent. So there are some differences there. Now, the plaintiffs really resist the idea that this is a school finance litigation case, and they have framed it, Plyler is a big part of their argument. And so they're saying, you know, this is not about money, this is not about how much money people spend, which I get. And at the same time, if there's going to be a meaningful remedy, it's going to involve money. And so it's interesting that they're really trying to distance themselves from school finance litigation. And yet, I think inevitably, some aspects of those conversations are going to come around again. Now, what would a remedy be like? Now, plaintiffs are really focusing on this as an opportunity to become literate. So they've been intentional in terms of saying this is not about actual outcomes, this is not about actual proficiency levels, this is about having a system that gives children a real opportunity to become literate. Which then leads to another question, what do we mean by literacy? And it's interesting because I think we could have a lot of different answers to that. In fact, if we think about ELL proficiency, 50 states have 50 different answers for when non-native English speakers become proficient in English. And it's interesting to think about literacy as something similar there, right? Because if we're talking about something that is a meaningful right, we're not just talking about, hey, I can sign my name. Are we talking about reading at grade level? Well, maybe, but that seems, we have to be really careful, again, that doesn't slip into an outcome because we're still talking about an opportunity to achieve that. Or are we talking about something a little more flexible than that, right? So if we're thinking about, well, an operating manual in the U.S. military is written at 8th grade reading level, then is that basically what we're focused on here in terms of what children should have an opportunity to do by the time they graduate from high school. So there are a lot of really, really interesting questions in this case. And part of what's been so fascinating for me to see as I have followed this case closely is the way, and this brings us full circle, right? The way in which the parties in this case and the district judge in this case do not think about this as though school finance and school deseg are a double helix. They're thinking about all of these issues combined. And if we read the district court decision in this case, it's like they're trying to relitigate both Brown/Milliken and Rodriguez in the same case. And so they're struggling with a lot. They're grappling with a lot. And part of what I'm wondering is, in this case, and then also thinking of the case that's coming out of Rhode Island and Michael Rebel's theory of education for citizenship, and in particular his litigation theory, which obviously picks up on a long strain of engagement with that idea in the literature. Are these things really coming together in a way that is very different than the double helix sort of idea that we have had in the past? So those are my thoughts about what's going on here with, it used to be Gary B. versus Snyder. Now it is Gary B. versus Whitmer, a case that is likely to be argued in the Sixth Circuit here at some point in the next 6 months.
Thank you. So the panelists have given us a lot of information. Thank you all for your wonderful presentations. In an attempt to both give a summation and provoke more discussion, I've been taking notes and drawing maps, trying to link all the moving parts. And I think it's important for us to acknowledge that there are a lot of moving parts. And that actually is part of the original beauty of Brown and also some of its enduring complexity. As we know, Brown, the 1994 decision, fairly short, for a case that had been brought twice to the United States Supreme Court by 1954, with a lot of amicus briefs and a lot of pages in the overwhelming volume of social science. Probably one of the, not the first case involves such large volume of social science. And then for the Supreme Court in its decision to largely footnote the social science, produce it, there were amicus brief patches submitted by the federal government that didn't really get a lot of traction. And if you were to read some of those briefs, you will see that these arguments, that they occurred to the parties then, they occurred to the amici then, and that they are still with us now. Also, part of it is we assumed a lot was embedded within Brown. And I think as lawyers and the law community, we should, of course, know better than that anything in the case that was not. But that carried for a while, particularly with the war, where a lot of the assumptions that were embedded in Brown eventually became part of the decisions from the Brown 2 factors, which I have questions about for our panel, all the way through Alexander versus Holmes. So the framing of this panel was about from Brown to now, specifically looking at issues of resegregation. And so one of the things that Professor Green brought out in his presentation was, well, we're living in a very largely segregated environment. It has become more segregated. 1.2, in I think Bangor case involving Pasadena Unified School District in 1980, in which the court said, well, if the state isn't responsible for driving segregation, how can the state be responsible for remedying that particular segregation? Now, there's a bit of fiction in there, but if you look at the cases that Bangor cited, if you look, there was actually no evidence brought to bear linking state government, and the school district, and the decisions to district in that manner with housing segregation. So one immediate way of thinking about this is the things that we don't prove empirically can eventually be undone. So the link between the social science community and the legal community, to the extent that we're interested in identifying what is actually causing educational disparities, we should probably pay more attention to that. But also embedded behind what Professor Bowman just talked about is the Millikan decision. We talked about Millikan in, but I think we need to bring that much more to the forefront. We wouldn't be having a conversation about resegregation without Rodriguez and Millikan. The idea that whatever remedies we can have we couldn't have cross-district remedies, ignoring the fact that the states also established where the district lines are drawn. So it doesn't even get you to the Spangler point where you're trying to abstract away from housing decisions. You're actually talking about where do we draw district lines, and those lines are as impervious as borders in many real respects, which we bring us to immigration issues. Is a part of the conversation, particularly given Flagler and the role of Flagler in this whole scenario. So Flagler is important because it's the only case that I can identify, and please correct me if I'm wrong, where in the Burger Court, from the Burger Court going forward, the Supreme Court said, wait a minute, you can't do that. You can't deny students functional opportunity to education. And it's a functional opportunity. So you use double helix on science. I tend to think in calculus. Forgive me. So I think of things like limits and asymptotes. That as you approach zero, I mean, you're laughing, but you're going to love it. You're going to love it. There's no way you can't. So if you think about asymptotes, the idea that you're going to approach zero, but you're never actually going to get either as a lower or upper limit. Think about we cannot deny opportunity. No one's really trying to completely deny opportunity to students now. And by complete, I mean you actually have to say one on a binary, 0 to 1. No one's creating laws, no one's trying to enforce laws to say that you cannot attend school, either elementary or secondary. That's not happening. So they are saying things like you have to attend school in the district. And they are saying things like, well, it may cost you money to go to college. And you can charge different rates of tuition depending on what your residency status is, either within the state, district for some community colleges or as a United States citizen or person that authorized them. So we are saying things that get you really, really, really close to saying you don't have an opportunity because we understand the relationship between where you live and the types of education that you are getting access to, or if you're given access to education at all. And it's something I didn't know until this presentation. You may sign away your rights in an attempt to pursue better education. So I'm interested in understanding where those limits are. I think that's another way of looking at the Gary V litigation. It's arguing the limit. And that actually might be a strategy moving forward in a way that you don't necessarily have to talk about positive rights. I think I've hit on everyone's topic because they're all connected in my mind. There's an entire web going on right now in my head, and I hope there's one deep created in yours. But so as to clarify, with Latinx students, we see a lot of the cases that have emerged with good outcomes have involved Latinx students in ways that cases that involve African American students primarily have not. So Westminster versus Memphis, which was the precursor to Brown versus Board, was right here in California. It was a case largely brought against the California state government operated by then Governor Earl Warren, which influenced Brown. Loud versus Nichols was actually involved students right here in San Francisco, and how students who had been forcibly integrated, Chinese American students who had been forcibly integrated, were not given English language education. Now, the Title VI justification for Loud versus Nichols has since been undone by statute, but it is a landmark decision that also had major contributions by MALDEF and Latinx students and their experiences around language acquisition. And of course, Pilot versus Doe involving undocumented migrant youth. What can we do to the panel, each of you here, and please feel free to speak, to the breadth of your own expertise, which all three of our panelists, I actually have to constrain what they spoke about because they can each give a course on approaches for educational rights. What can be done to streamline the array of cases toward identifying what in Rodriguez is still an open question? What is that quantum of education that each individual in the United States has a right to? Because Rodriguez didn't say that education is not a fundamental right, it just said that we haven't been able to find it here with this particular question on education finding. I should probably start with Professor Bowman since we are talking largely about the question behind the Gary litigation. So what is that quantum? How might we identify it? Where does that fit within all of the various permutations? And also feel free to talk about the brown shoe factors and where we are with those. Again, you a lot.
So just a few thoughts, and then I would love to hear from my fellow panelists. I was so pleased to see how much coverage the Milliken case got in national media recently. And it was a significant anniversary for the Milliken decision. But I think, I'm glad to hear your comments about it because that is one of those cases that I think we have really been delayed. And by we, I mean, we in a very broad sense have been delayed in understanding the significance of what it means to limit liability to school district lines and to deny the role of the state in establishing those lines and to deny that as being part of state action. That's a really important factor and really significant for so many educational equality issues that are very different from one school district to another. So continuing to think about that and talk about that, I think is part of this, right? And I mention that because I think of this as, I think of this similar to how the Gary V case is approaching it at a very general level. I think of this like a system, right? And so unless we continue to make the system visible, then the system's just going to continue to perpetuate the same results that have been occurring, right? But it is in visualizing the system, seeing the system, that we can say, okay, so how does this connect to that? And what exactly is going on here? And if we change this aspect, how might that affect a lot of other things downstream? And so really recognizing and thinking about the important ways in which Millikan influences what can be done is very important. And also recognizing that, you know, as with all of these cases, that was an open question until the Supreme Court decided it, right? You know, it's not something that is, you know, it was always foreordained that this is the way it was going to be. So that's one aspect of it. And my other comment is that you asked about streamlining, and I'm not sure whether we want to, because when I think about a lot of these cases, like what was going on at the time of Rodriguez, you know, there were cases coming up in a half dozen different states, right? And so eventually they became consolidated. But it's all, I think, about trying to figure out different approaches, and sometimes just slightly different approaches, and figuring out where we can get some purchase and really moving forward from there. Because I think I know you're not saying, let's put all our eggs in one basket. But I think when folks think about streamlining, sometimes they're worried, or sometimes they go a little too far and go in that direction, which I think would not be a good idea when we're thinking about educational equality, especially because the issues are so diverse, right? And we have a lot of different groups of students that need different things. And so keeping that also at the forefront of our conversation is, in my view, a really important aspect of this.
Definitely think Bowman's comments about how these things, also how I think also keep us from I think about the scripts that I did years ago, looking down what it is talking about. Well, one thing, I thought about this all the way structures. And so I can say that we definitely got to start fighting. And think about that, the works out right now, what are we not doing? What are we not doing? We have a long time really established those that we learn less about trying such that we have a working approach. So I look at this more as a long battle. That's the
So I actually just wanted to on this really frame is out of the movie. There's an effort to now realize talking about race and economic and the attorney who brought the case unwilling. And so eventually, Martina was involved and tried to reframe this as finance to build on the momentum of a decision in California, which has turned down the property-based finance. So, in a way, they got. So the intuition about the property later. And you did say that, like, right? It was a big setback for the Mexican American time. Allow decisions of rehabilitating himself by saying that at least there's some ways to have problematic access to education, although it was poorly. So I think, you know, there's a connection, and what's interesting about that case, I interviewed him on property. This fellow and someone had come in to complain about a tenant during a lot of issues. He told me at the time he knew that this case had to be loud and outdoor. So I think that the idea that Latinos were somehow always, you know, doing well, but in some ways I think he felt they needed to block the case of bilingual education, although the case primarily affected Spanish speakers. And finally, I want to say about Filer that at the time Filer was because it came after Rodriguez, right? And it basically stitched together the problems of unequal access and the unequal access based on national origin. Together, there was a dignitary farm in the permanent class to be living in our midst. And I think that in many ways, Filer it isn't just the equality or controversy. It stitches these two things together in a kind of quality with one another. And the time it was starting, like policy making, there were efforts that were done legislatively, which failed when the have to, like Fletcher was actually quite popular. Whether California overturned it, and the court said you can't do that. That's constitutional law. We can't just ignore the U.S. Constitution. And so Fletcher has had kind of a talent status, but it's had very little traction itself. So I think it's going to respond to its past. And I think there's a number of cases like that that are potential anomalies, which temporize while not undoing some of those principles that have put the court in the box. And I think the problem is
probably should have stayed standing, so I'm going to do that going forward. I think the ultimate question is, what is the state actually responsible for? And all the variety of sub-questions. So what is the state signed up for? What has it written in its constitution? What are the consequences of that? Could the state write things out of the Constitution? Which is somewhat of an open question. The idea that the states do not have an obligation to provide education, but since they have done so, here's what that might mean. They have the obligation to provide it in an equal manner. That looks like is the state responsible for all of the other, ancillary effects, consequences, the causes of educational disparities, including housing, including roads are built, including how districts are established, including jobs. I mean, we could take this to a number of abstractions. Where is the state responsible? Then we have the idea of what is the state actor? We talk our charter boards or educational management organizations, are they state actors or quasi-state actors? What are the consequences of identifying them in either category? At the end of the day, I think we really need to focus on what the state's responsible for. And some of this is jurisprudential, some of this is philosophical, but some of this is also empirical. And it may actually require some, in a very long, sluggish movement, some basic establishment facts. Like, what is the state responsible for? Because if the state isn't responsible for something, then it's going to be very difficult to say that the state has an obligation to remedy it in some manner or another. I'd like your thoughts about that.
I have to say that I think the reason like little impulse is responsible very clearly. We do not have a right to shelter, right? It's an issue of health care is a right. But, you know, we rejected all kinds of minimum entitlements. And as I came on from here today, I saw people on the street and apparently. So I don't really think that education is in terms of rejection of basic rights and the principles of the effort to do it altered, well turned right, well. And so my sense is that there's been a shrinking notion of what or that in many ways the current presidential campaign with the strong presence of progressive voice has been a battle of saying, wait a minute, who is responsible? So I think we're going at this moment into a very national struggle over the question of state responsibility. What makes education unique is that the state does such a substantial job of providing it. But that has been now by arguing that maybe the state should be responsible. Maybe we should privatize it. It would be more efficient. And in any event, where does it say in the Constitution that the state has to provide education? I just think we're in the midst of a contestation in the face of the most unprecedented wealth and income inequalities over what the state's a private market of all against all, competitive process of winners and losers, and give them. I think that's where we are. And I'm not sure, you know, that education except insofar as we continue our ability and to become right on the listen that's about the way we're doing it. And I think that's
I guess I would look at that and say that in the area that I study, one of the areas I study privatization, certainly do see the state moving away. And in that, there's this sense of saying the parents are the ones who make decisions without legal guidance. And I can tell you in the research that I've done for years that parents need help. Definitely need help. So I'm hoping that we're starting to see people. I think that in my research and some people to are starting to understand, but there is a place for government, there is a place for oversight. If we go such that people get the protections that we need. So that is certainly a major mine. That's what the struggle that we're having. See how it plays out. Professor Bowman, can you hear me? No. Professor Bowman, can you hear me? Yeah, you can hear me.
Professor Bowman.
Yes, I can hear that voice.
Okay, can you hear me now?
But I've been having a hard time during the Q&A, and I'm so sorry to miss out on engaging in this discussion in more detail.
Can you hear me on this microphone?
Yes.
Okay, so I'm actually going to use my projection voice to make sure that you can hear me. If I'm speaking too loud, just wave and I will lower my voice. So the question was, what is it actually responsible for? And Dean Moran and Professor Green said, we're in a neoliberal era where the state is not responsible for a lot. At the same time, we're providing more choices without information. I mean, the economists would say that we are making the information more imperfect, which is interesting against the idea of efficiency that economists like to always say that neoliberal policies would promote.
So you will have the last word before we close. What is the state actually responsible for?
Wow, no pressure there. And after this, I'm going to go, create world peace. If I could answer this question. I think asking this question is a really important thing, and I don't have a direct answer to it. I have an answer of what I think the state should be responsible for doing, and that grows out of my worldview, and my scholarship grows out of that worldview, right? Thinking that, as I tell my kid, he's really lucky to be born into a family where mom's a law professor, dad's an anthropology professor, and we're able to go in and figure out what's going on in his school, have conversations using all of our social capital, and choose to live in a school district, whichever school district we want to, right? So I tell my kid, I do the work that I do because not everybody's family has the advantages that ours does. And in my view, a key role for the state is to make sure that kids are not disadvantaged because of the relative capital in whatever way of the family that they're born into, right? It's thinking about how the state can help each child realize his or her potential, because ultimately that's not only what's best for individual people, but it's also what's best for us as a society if we're able to really leverage all of this collective strength and potential and ideas and innovation. So in my view, that's what the state is responsible for doing. But of course, we've had decades and decades of litigation where folks have taken very different views, and where that has been the heart of the question at so many of these cases.
Thank you. And I will respect your time, so I will be quick. So it seems from the topic generally and the presentations and the comments responses to the question that we really need to identify how I'm going to try to do this. And I think that's probably part of the problem, is that the idea that this has to be reduced. How are we going to both hold the state responsible to the promises that it is making, to educate all children against what appears to be a very seductive line of argument? Part of the reason that the neoliberal argument works is because for 90% of the argument, it's elegant, it's simple, you can follow it. The state is responsible for the things that the state says it's responsible for. Education is not listed among those. To the extent that we have introduced in our state constitution, is limited by those very few words. We all of us who attended law school took classes on statutory interpretation. It follows. The problem is where it has to leap in order to reach the conclusion, or is a very important template. There are a lot of unproven assumptions in getting from the state not responsible for segregation, not responsible for providing different educational opportunities. It's not responsible for allowing certain schools to have advanced placement courses and others not to address it. It's not responsible for allowing community colleges to exist without meaningful transfer options. It's not responsible for giving some children a plethora of educational opportunities they can't take advantage of during the school day and others none. It's not responsible for a single-digit literacy rate for children who attend school every day for 180 days a year or 13 sometimes. It's not responsible for that. So I think a lot of what we're saying, this is the charge that I have to each of us who are going to go out in fighting this work, to actually help the legislature define things in ways that promote education for every child. And that might not necessarily be the most politically feasible option in a lot of places. And places where it isn't to ground our litigation not only in the jurisprudence, but also in really careful conversation with social science. I think that's honestly our best way forward, is to expose where those leaps in logic have been made and expose which have been false. So with that, thank you so much for your time. I would like to thank our panelists again for the Resegregation.
Thank you so much, Kristine.
Thank you.
Thank you so
All right,
much.
are we fit? My pleasure.